Um, Hopefully, I will not take an hour.
Good morning, everybody. Good morning, good morning, good morning. We have closing arguments today in the Breonna Taylor case. One of the things that you're going to hear this morning is that even though the warrant was issued as a no-knock warrant, they're going to profess that they did not go administer it as a no-knock warrant. So this morning, we're going to hear a lot of details about what happened on the night. We're going to see video. The closing arguments, you get a lot of more leeway in the closing arguments. So this is going to be really interesting and really informative about what actually happened on the night. I believe it was March 2020 when Breonna Taylor's life was taken away. So we're going to hear details tonight, closing arguments. I have a poll in the chat. Let me know if you believe Brent is guilty. He is charged with first degree and second degree of wanton endangerment, right? Pretty serious charges. But they also have a lawsuit for $12 million for each of the individuals. I don't know. Does anyone know? Can you put in the chat how much money did Breonna Taylor's family receive? Was there a payout to Breonna Taylor's family? Because this family in the adjacent apartment is suing for $12 million apiece, $36 million. That's not for Breonna Taylor's family. That's for the family in the apartment. So I need to know, can someone put in the chat how much money did Breonna Taylor's family get for this shooting? Or did they get nothing because it's a justified shooting? Were they barred from suing the city because the shooting was deemed as a justifiable shooting? That would be horrible, you guys. Let's do some research. Let's find out. Was there a civil lawsuit in the Breonna Taylor case? Was there any recompense for the Breonna Taylor family? Or are they just going to have to swallow this wound and accept the loss of their daughter? I don't know. But let's get into the closing arguments. Good morning. My name is Perfect Time. And make sure you give the brother the hook, the brother up special. That's the HBU. That's the hit the like button. That's the hit the share button. That's the hit the thumbs up button as you come in. Make sure you let everybody know all my riches, my 5.0 solidifiers. Stand by me real closely. Make sure that the chat is going smoothly. Make sure I see them 5.0s in the chat. Make sure I see them good comments in the chat, because a lively chat is what makes the algorithm push out the video. So everybody come in and say good morning to everybody. Everybody say peace and blessings and prayers up. I'm going to say a prayer real quick. God, thank you for the opportunity once again to come before you and have this glorious platform and speak to my audience, and then educate fathers and families on plans and ideas to move forward in Black male progression and overall male progression. Father, I pray a covering over the listeners to my word and to my audience. I pray safe passage of all those on the highways and byways, a blessing unto those. And Father, I ask for forgiveness for all my sins, and I ask that I How does that go? Forgive me for my trespasses and forgive those who trespass against me. I know I got a lot of enemies, a lot of haters, but I just want to let everybody know I forgive you, I love you, and we moving forward. I can't be stopped as long as God got my back. And the same is true for you. The same is true for you. Okay, the blessing is not only mine. Amen. So we're getting into it, man. Closing arguments, Breonna Taylor case. Everyone have a beautiful, blessed morning. Make sure you share the video in your Facebook groups like we discussed. All right, let's get to it. Let me know in the chat what you think. Again, Brett is not on trial for the death of Breonna Taylor. He is only on trial for shooting into an apartment. All he did was shoot drywall. He is on trial for shooting drywall and being a bad cop. And he is a scapegoat for Breonna Taylor's death. This is political theater. The only reason this case is happening is to satisfy the bloodlust of the BLM mob. Let's get to it.
But I don't know. I haven't timed it. Ladies and gentlemen, I'd like to start out by thanking each and every one of you for agreeing to participate in this trial. We've been here, it seems like, for long days, for a lot of days. We're now at the end. But I know you've paid close and careful attention. I've seen all of you during the course of this trial taking notes and paying attention. That's all we ask you to do. I'm not going to delve into all the facts. You've heard facts over and over again. I don't think there's a whole lot of dispute between the Commonwealth and between us over most of the facts. Some of the facts are disputed, but most of the facts are not. The big dispute in this case is how do you interpret those facts? And before I get into a lot of things, I would like to, there are a few issues I'd like to discuss preliminarily. First and foremost, I think everybody in this courtroom and probably everybody in this world agrees that the death of Breonna Taylor was a terrible thing. As Brett Hankison said yesterday, it should not have occurred. I think we can all agree on that, but I think we all know that this case is not about the death of Breonna Taylor. It's about Cody Etherton, Chelsea Napper, and their son Jaden. And what happened to them is a terrible thing also. But fortunately, none of them were physically injured. You saw particularly Chelsea the other day talk about the trauma and the emotional upset that it caused she and her family. And there's no disputing that. You'll have defendant's exhibit number 1, and I apologize for sounding a bit callous here, but you'll have defendant's exhibit number 1 in the jury room with you, which is a copy of a civil lawsuit that they filed against Louisville Metro government, the Louisville Metro Police Department, Detective Brett Hankison, and 8 or 9 other police officers, which seeks as compensation for what they've been through in 3 different counts, $12,001, 3 times over. So for a total of $36,003 is what they're seeking for compensation. And while I suspect they're not going to get that kind of compensation, I believe they probably will get compensated as a result of this. That's not going to undo what happened on March the 13th, but I think it would go a long way toward alleviating some of the emotional distress that they've been put through. Ladies and gentlemen, there's a common denominator to this case, and that person is not on trial here. That's Kenneth Walker. He's the fellow who fired the bullet, the initial bullet that struck Sergeant John Mattingly while he was in the performance of his duties as a police officer, serving the search warrant at 3003 Springfield Drive. The search warrant itself was something that the officers all had a right to be where they were. They were doing what they were instructed to do. The problem is with that search warrant is that the officers were ill prepared to go out to 3003 Springfield Drive, as it turns out. You know, we've heard testimony about no-knock search warrants, and you have heard those described to you as what that is. We've heard that this was served as a knock and announce warrant. The no-knock warrant is how it was issued. That is, the police had the right to go out to 3003 Springfield Drive to Breonna Taylor's apartment and just break in that door and search for the documents and whatever else, whatever other contraband they may have been looking for or could find. They, somewhere along the line, they were told not to do that. Go out and knock and announce and let the folks know we're here. And the reason that that was done is, number one, the information provided to the officers who went to 3003 Springfield at the briefing at the CID office on Ormsby before everybody went out on these different search warrants was that at 3003 Springfield Apartment 4, there was a single female living there who had no children, no pets. There was nothing there to indicate that there would be any problems with the execution of the search warrant, no issues. So it was considered a low risk entry that they were going to make. So be courteous, knock and announce, and let somebody know we're here and give them a chance to answer the door. Well, what happens? The police show up, they knock and announce, and there's been a lot of controversy.
Good morning, everybody. That's our first break right there. We got to pause right there because me and Sunclaw, the whole country, now we have guns rights activists, everybody discussing. We have a brand new case. The brother's name is Amir. He was murdered on a no-knock warrant. So please pay close attention. I know he's a white man. I know he got white hair. And we're not watching this for entertainment. You need to be taking notes because this will be coming up again for a vote very, very soon because there are white guns rights activists who want this no-knock warrant issue addressed. There is a reason why this case is happening. I am discussing political theater this morning. There is a reason why he is juxtaposing no-knock warrants in his closing arguments the way he is doing so. He is saying it is against what actually happened and what I have stated. They issued this warrant at 2 a.m. under the cover of darkness. The expert testimony and my brother Sunclaw talked about the flashlights on the guns and how they cut the lights off on purpose. And sometimes you can have the flashlight on, but they purposely went in under the cover of night. That contradicts this closing argument. He said they had permission to do a no-knock warrant, but what did he say? He said what I said yesterday. I tell you, ladies and gentlemen, they listen to YouTube. They listen to YouTube. They listen to quality YouTube content creators. I said yesterday, why did they go in under the cover of night when she was not a criminal, when they had no crime against Breonna Taylor? Did you hear what he said? He said all we needed to do was ask her questions, right? All we wanted to do was ask her questions. So go nicely, knock on the door, and ask a couple of questions. Now, everybody in the chat, why do you need 7 white men with guns, a dog, bulletproof shields, 2 a.m. in the morning, flashlights, if you just needed to ask Breonna Taylor questions? Share my video. Share my video. I know it's early. That's why I took a pause in the beginning so YouTube could push out my video. And the fire is starting already. Perfect timing going in already. Yeah, I've been doing a fabulous job. God is good. That's why I pray. God is good. God is the greatest, man. I am perfect. I said this yesterday. This white man ain't got shit on perfect timing. I said this yesterday. Huh? With the breath and the energy that God gave me. Why would they go in the cover of night at 2 o'clock in the morning when they knew that this was an American citizen who had committed no crime? If this was a white woman, they would have called her on the phone. Excuse me, Mrs. Taylor, 6 months ago, you dated a Pookie. We would like to ask you a couple of questions. You know what the white bitch would have said? Fuck you, and hung up the phone. Because I don't got to tell you shit about who I fucked 6 months ago. Does anybody understand the case? I don't believe nobody understands the case because black men don't love themselves and thusly black men don't love black women. So when Sandra Bland is murdered by a white police officer, when Breonna Taylor is murdered by a white police officer, nobody cares. All the black men are saying she's so dope. All the black men are saying she was a criminal. and no one knew the details. Well, now we know the details, black man. What do you got to say about Breonna Taylor now? All they wanted was to ask her questions. She had committed no crime. Why did they get issued the no-knock warrant? This is why you have gun rights activists wanting to outlaw no-knock warrants. Why are you getting a no-knock warrant on a black man who has a legal license to carry a gun? He's not a criminal. He's innocent, just like Kyle Rittenhouse until proven guilty. Breonna Taylor, innocent, just like Kyle Rittenhouse until proven guilty. How do you get a warrant for someone who's never committed a crime? How do you get a no-knock warrant for a woman who's never committed a crime? I'm going to qualify it further. How do you get a no-knock warrant to go in at 2 a.m. with 7 men and guns, a dog, a bulletproof shield for a woman who's never committed a crime, and you don't even suspect her of committing a crime? Does anybody hear me? Is this motherfucking microphone on, you motherfuckers? Is this motherfucking microphone on? Perfect Timing is in the building. Give me the HBU special. That's the hooker brother up. I'm live on 3 channels right now. Perfect Timing Podcast Live. I'm also live on Facebook Live under Patrick Potter. Shout out to all of my Facebook viewers and listeners. Facebook is growing up. I swear to God, Facebook, I love you. Everybody say Facebook is the place where people make more money than YouTube. Telling you, Facebook, show me some love. And I will say, fuck YouTube, because YouTube don't give a fuck about me. So Facebook, get on your job, Facebook. Everybody on Facebook, hit the thumbs up. Share me on Facebook. Share me on Reddit. Share me on Twitter, because YouTube is bitches. Everybody on YouTube is bitches, and nobody could do what I do. Ramil over there with 700 people talking about bitch shit. And this is real shit right here. How many black men have guns? How many black men have license to carry? How many black men have concealed carry? How many black men will be subjected to no-knock warrants? But I know what we should talk about. We should talk about simping. I know what we should talk about. We should talk about pump and dump responsibly. That should be the topic of the day. No, the topic of the day is the no-knock warrant and how this white man said we only needed to ask Breonna Taylor questions. For the people in the chat, if they only needed to ask Breonna Taylor questions, why did they go in under the cover of night? Why were they issued a no-knock warrant? Why did they have 7 men who had never worked together, who were ill-prepared with guns and dogs and bulletproof shields? It was a recipe for disaster. I'm surprised more people weren't killed. I'm surprised more people weren't killed. This was a clusterfuck, foobar, fucked up beyond repair. These officers all deserve to be fired and incarcerated. They foobarred this whole situation, fucked up beyond repair. I'm going to put that in the chat. Hashtag foobar. This ain't the flex crew. This is the foobar crew. Fucked up beyond all repair. Bullshit.
About whether knocking and announcing occurred, every officer who testified here said that we knocked for a prolonged period of time. We announced ourselves as police officers, and the issue is, are the officers telling the truth? Well, we heard from Aaron Sarpay, the neighbor from upstairs in apartment 8, not the neighbor, he was in apartment 8 upstairs picking up his daughter from the babysitter. He came in, and in the courtroom here, he denied hearing that the police announced themselves or identified themselves as police officers. But you heard a taped statement that he gave to Detective Herman Hall with the Kentucky Attorney General's office early in the investigation, admitting, or not admitting, but stating that he heard the police announce themselves and identify themselves as police. He's backed off of that at this point for some reason. But he heard it. He's an independent witness who verified that the police did identify themselves. So that's the irony of that situation is that had the police gone out there and done a no-knock warrant and just broke in the apartment, nobody would have had an opportunity to get a gun and shoot Sergeant John Mattingly. They would have been taken, in all likelihood, taken by surprise, and this incident never would have occurred. Aaron Sarpay.
So for some reason, he felt the need to defend the no-knock warrant. Did y'all catch that? For some reason, because it's been the paramount issue for the past 2 years, and there's been a recent murder of a brother named Amir who was a licensed gun carrier. They were able to get a no-knock warrant, and they murdered this brother. Now you have white guns rights activists saying we need to get rid of no-knock warrants, but for some reason the no-knock warrant is not on trial. But he felt a need to justify the no-knock warrant, even though his own witness recused his testimony. Did you hear that? He said he had a witness who testified that the police knocked on the door and announced himself, but then recused himself. Now remember, under cross-examination, Brett testified that he was at the back of a 7-man pack and he was talking to the neighbor, and the sergeant told him STFU. The prosecuting lawyer said, how could you see and hear someone knocking on the door if you were at the back of the pack talking to the neighbor? He said, I apologize, I did not see him knock on the door. This is under testimony. But for some reason, they're still wanting to drive home that these police officers knocked on the door, when obviously they did not knock on the door. Why would you get a no-knock warrant if you were going to knock on a door? Somebody, I need to get a new poll in the chat. Why would you get a no-knock warrant if you were going to knock on a door? Why would you get a no-knock warrant, go at 2 in the morning, have 7 men, dogs, bulletproof shields, and then kindly, what the fuck is that? What the fuck is that? That's what you're gonna do? It makes no sense. It makes no sense that after you get a no-knock warrant, 2 o'clock in the morning, you got dogs, you got vests, you got bulletproof this, you got all this shit, and you knock on the door nicely. What the fuck is that? No, that's not what happened.
Remember his testimony. He number one, he said police identified themselves as police. He also said that when the entry was made, he was back in the apartment 8, because he and Brett Hankison had a little disagreement about him being outside and him wanting to come out. Brett sent him back in the apartment. He went back in, but he said when they broke into that apartment, it sounded like a machine gun going off. He's an Iraqi war veteran, and he knows what the sound of a machine gun is. He said it sounded like a machine gun going off. And that kind of sets the tone for what Brett Hankison was appreciating at the same time and why Brett did what he did. The Aaron Sarpe recovered, as you'll recall, and I don't know if this is has any bearing on this case, but I thought it was somewhat important to discuss, and that is the .223 spent casing that Aaron Sarpe found in the gravel that was between the sidewalk and the patios of these apartments at 3003 Springfield. We heard testimony that an AR-15, that's the type of ammunition that gun uses, that rifle uses. You heard Brett Hankison testify that when he saw the muzzle flash as Kenneth Walker discharged his weapon, or whoever shot the Luger, the 9mm gun that struck John Mattingly, you heard Brett say he thought that he saw in the muzzle flash an AR-15 rifle, person in a rifle stance. Well, Aaron Sarpe recovers a .223 spent casing outside. So what? Not a big deal. Curious, but probably doesn't mean anything. But then later on, we get another report that there's a .223 spent shell casing found in the bedroom in apartment 4 that was apparently missed by the crime scene unit when they methodically and completely searched apartment 4. They didn't find it, but at some point that casing was turned over to the FBI. It was found in the bedroom where the gun that was used to shoot Sergeant Mattingly happened to be found, and where the window was located that Brett Hankison fired 5 rounds through on this night. Now, again, does that mean anything? Is it a coincidence? Well, we heard Bryce Ziegler, the FBI criminalist fellow who did the firearms examination. He said the spent casing found by Aaron Sarpe and the spent casing found in the bedroom in apartment 4 were fired by the same weapon. Now, I don't know if that means anything or not. He didn't have a weapon. There was no weapon found when CSU did their complete and methodical search. But we also know that the family of Breonna Taylor was granted access to that apartment later in the day on March 13th, the same day this incident occurred. Does that mean anything? I don't know. Is it all coincidental? Perhaps, but I have a problem with coincidences sometimes. It just is a bit curious.
Did he just suggest foul play on the part of the family of Breonna Taylor after their daughter was murdered by police in the haphazardly issued no-knock warrant at 2 a.m. in the morning? Are you suggesting? Look how bold and cavalier that statement was. He is suggesting that the family of Breonna Taylor, the murdered victim, after a haphazardly no-knock warrant was issued and she is no longer here, he is insinuating foul play on the side of the Taylor family. You motherfucker, you.
Another issue that I find a bit curious in this case is that we know that there were 2 occupied apartments that were struck by gunfire, that of Cody Etherton and Chelsea Napper and their son Jaden. We also know that bullets traveled into apartment 8 upstairs where Aaron Sarpe was picking up his child from the babysitter. It's interesting to me, and we know from Michael Van Arsdale, the FBI trajectory expert, we know from him that the bullets that went into apartment 8 did not originate from Brett Hankison just by way of the trajectories. We know they originated from somebody firing at the front door, either Miles Cosgrove or John Mattingly. It's interesting that the only person charged with wanton endangerment for the same conduct is Brett Hankison. Why the Commonwealth chose to charge Brett Hankison with wanton endangerment is a question I've asked myself since the day that an indictment was announced, but nobody else got charged, which was the proper decision, was not to charge anybody, period. I believe, ladies and gentlemen, that Ms. Whaley or Mr. Finke in their closing argument are going to come up and talk about the rules of shooting and how Brett Hankison violated all of those rules. You know, you've heard them over and over again. You have to have a target in sight. You have to know what's in front of, behind, or beside that target. And Brett Hankison didn't do that, is the allegation. You've heard the testimony from Brett. He testified that he saw muzzle flashes at the front door of that apartment. First of all, the apartment was breached, and you have to keep in mind that this entire shooting part of this, from the breach of the door to the end of the shooting, has been described as anywhere from 5 to 15 seconds, I believe. That is fast. The criticism of Brett is that once John Mattingly, his friend, was shot and said, "I'm down," Brett moved away from the fatal funnel that's been described and around the side to the patio to the railing where he had a view of the sliding glass door, and he saw the muzzle flashes inside of the apartment. Now, there's been testimony, I think Jason Vance described the curtains that covered the blinds that were over the bedroom windows and the sliding glass door as blackout curtains. Well, a blackout curtain implies to me that you can't see anything through it. And Brett Hankison said that he saw muzzle flashes. Now, people say, well, he couldn't have seen those muzzle flashes. Well, nobody can say what Brett Hankison saw or didn't see. Only Brett Hankison can tell you that. But you'll have with you in the jury room, Defendant's Exhibit 5. And this is a picture of curtains. These are the curtains that were on the bedroom window. And you'll be able to look at that and you can see through those. And I would suggest that blackout curtain was not an appropriate description. There were curtains, there's no question about that. But Brett said he could see muzzle flashes through it. And I think this shows that you can at least see them through the bedroom curtains. I mean, this is a good picture to show you can see through the bedroom curtains. Additionally, so the curtains, I think, are one thing. There's also, you'll have photographs that the Commonwealth introduced that show a mirror on the wall in the living room. What do mirrors do? They reflect things. And I would submit to you that potentially that mirror was reflecting muzzle flashes. So I think that the claim that Brett did not see the muzzle flashes is one that is not proven beyond a reasonable doubt by any means. The next thing is that what he said he did is in response to seeing those muzzle flashes, he perceived that his brother officers were being executed in a fatal funnel at the front door. And when he slid around the side to that, where that patio is, and fired through the sliding glass door, he was firing at those muzzle flashes. That's not a target that is a human. You're not looking at a human being such as I'm looking at you and firing, but he is firing at muzzle flashes, which obviously had to originate from a human being. And he kept his firing inside of the apartment door. He wasn't firing at the officers who were out in the vestibule, because he didn't know they were there. He didn't know that, or he knew they were not inside the apartment. He thought the shooter was still inside the apartment. And when the firing continued, he moved down to the bedroom window and fired through that at the location where he had initially seen the shooter who shot John Mattingly. And you're going to have Michael Van Arsdale's trajectory report back there with you in the jury room when you deliberate. And you can see, and you saw it in here, but you can review it. And the shot pattern is exactly where Brett Hankison intended those to go. Unfortunately, 3 of the shots at the muzzle flashes at the front door went astray into the apartment next door, which we know that Brett Hankison and any of the other officers who were sent out to serve that warrant had no idea existed. It's not obvious when you walk up to the place that there's an apartment right behind Breonna Taylor's apartment. And you heard Miles Cosgrove in his video deposition say an operations plan generally would include information about the layout of the place we're going to, perhaps photographs. None of that occurred. They did not have a diagram. Nobody had any knowledge other than we're going to apartment 4. And I would submit to you that Brett Hankison did not know there was an apartment behind Breonna Taylor's that his bullets could go into. And I would submit that even if he had, he did what he thought he had to do in that instant. And that's what you have to be cognizant of, is this all happened in such a short span. He's a police officer. You know, it makes me think sometimes of when the plane struck the Twin Towers on September 11th. There were pictures of people running away from the smoke and the debris and everything that was coming down. And in those same pictures, there were pictures of police officers and firefighters running toward that danger. That's what emergency personnel are taught to do. They run toward the danger. And that's what Brett Hankison did here. He could have, when he swung out, and there's been some suggestion that perhaps he abandoned his brother officers when he swung away and went around the corner. He could have run straight out to that parking lot and just kept going, but he did not. He ran around the corner and took efforts to save what he thought he was doing was saving his brother officers as they were being shot in that fatal funnel. Ladies and gentlemen, the bottom line is that through all this, the Commonwealth is trying to say that because Brett Hankison took the actions he took, he's a criminal and he deserves to be in prison. I submit that Brett Hankison's the farthest thing from that. You heard how he reacted to try to save his brother officers. You heard everything he did, police-related activities that he engaged in after the shooting was over, including calling the EMS, notifying officers to come for backup, having an officer ram the gate, setting up a perimeter around the building. He's criticized because he didn't go right to PIU. There's nobody that says that that's a mandatory requirement. Chief Conrad said that's protocol, but it's not any kind of mandatory requirement. Brett went there to check on his friend and his brother officer, John Mattingly. He didn't do anything wrong by going to the hospital before he went down to the PIU unit, where he went after he left the hospital. and where several days later he came and provided a voluntary statement as he was requested to do, and as you saw on the screen here. So he's cooperated ever since. He doesn't believe he did anything wrong. Now, having said all that, ladies and gentlemen, the issue is, did Brett do something that was an unreasonable choice in the split second that he had to make a decision of whether he should do anything or do nothing? He chose in that split second to go do what he perceived needed to be done, and that was to save his brother officers. So he simply reacted as I would believe that most police officers would react when danger presented itself. The bottom line is, ladies and gentlemen, you have to be convinced of the truth of the charges here. 3 counts of wanton endangerment beyond a reasonable doubt. And beyond a reasonable doubt is not defined in Kentucky. It's simply it'll be the final 12 of you who are sitting on the jury. It's your collective agreement on what reasonable doubt is. And I would suggest to you that this case is full of reasonable doubt as to whether Brett Hankison committed the offenses of wanton endangerment. Now, the most important part of this whole thing is the instructions the judge just read to you. She read you the instruction of what the statute of wanton endangerment says. And if you read that, it makes some sense, but you can't understand it if you don't understand the definition of wantonly. So on page 3 of those instructions, the term wantonly is defined, just as the Kentucky legislature ordered it to be defined. And if you go through that definition, ladies and gentlemen, I think if you read it all at once, it's a little bit difficult to understand. But if you break it down into sections and segments, you have to look at a person acts wantonly with respect to a result or to a circumstance described by statute defining an offense when he is aware of and consciously disregards a substantial and unjustifiable risk that the result will occur or that circumstances exist. The testimony in the case, ladies and gentlemen, again, is that Brett Hankison did not know that there was an apartment behind Breonna Taylor's apartment 4. He didn't know of the existence of apartment 3. And I would suggest to you that in order for him to have consciously disregarded a substantial and unjustifiable risk, he would have to be aware of the existence of that apartment. It doesn't say be aware of or should be aware of. It says be aware of. That means he had to know that apartment was back there, and then he had to consciously disregard the substantial and unjustifiable risk. Well, there's two things there to consider. Number one, if you don't know it exists, how can you consciously or otherwise disregard it? And then number two is, was it unjustifiable? That's you all have to determine. Was it the risk, even if he knew it, was it unjustifiable for him to fire in what he thought was the defense of his brother officers, who he thought were being or perceived as being executed in the fatal funnel? As it turns out, they were not. His perception was wrong. But remember, he had to make that split-second decision in that very short period. The next sentence of that wantonly definition says the risk must be of such nature and degree that disregard thereof constitutes a gross deviation from the standard of conduct that a reasonable person would observe in this situation. Well, was Brett Hankison's returning fire on what he perceived as someone executing his brother officers a gross deviation from the standard of conduct that a reasonable person would exercise? I would submit to you that a reasonable person would do exactly what Brett Hankison did if he sees his one brother officer being shot and perceives that his other brother officers are in the line of fire and being executed. He did what he had to do that day. The fact that his bullets traveled through apartment 4, through the drywall, common wall to apartment 3 is a terrible thing. But it's not criminal, ladies and gentlemen. It's kind of like what you might call it collateral damage. Fortunately, nobody was hurt in apartment 3. just as nobody was hurt up in apartment 8 with the bullets that went up there. But I would submit to you, ladies and gentlemen, if after you consider all this evidence, you have to come to one conclusion, and that is Brett Hankison was doing his duty that night, doing his job. Things went terribly wrong, but his actions were not criminal, and he does not deserve to be sent to prison for what happened on March the 13th, 2020. Thank you. And I would ask you, ladies and gentlemen, please bring back 3 signed not guilty verdicts. Thank you.
All right, ladies and gentlemen, as I told you, we'll take a brief break. So let's break for 10 minutes and we'll resume the trial at 25 till 11. And please don't discuss the case with each other. Thank you.
All rise for the recorded jury. We not taking no break. 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 So right now, what you guys just saw was the defense. That was defense. That was defense for Brett Hankison. Shout out to Rainbow Tasha in the chat. Rainbow, I can't see your comments. Rainbow, are you subscribed? You gotta subscribe. We're in the members only mode right now. You gotta subscribe, but for some reason, I don't know if you're in incognito or I don't know what's going on, but I can't see you. I don't even know how you did that. So Rainbow, you gotta come up and tell me how you magically did that, because I can't see your comments in none of the chats nowhere. If you was on Facebook, it would tell me, but thank you. I updated the title. We got Brett Hankison in the title. We got Cosgrove on the thumbnail. And I got Breonna Taylor up there because I need people to come to this podcast so they can understand and be educated about this issue, about the greater issue of what's going on. No, this is not about Breonna Taylor. Breonna Taylor will never get justice. Breonna Taylor's shooting death was deemed justifiable by Daniel Cameron. If you this will be a series, Rainbow. And I got 3 episodes. Go back to yesterday's episode, and I brought up the picture of Daniel Cameron. Daniel Cameron is the Attorney General for Kentucky. He's the first African-American Attorney General of Kentucky, and he's the first Republican Attorney General since 1944. One more thing to know about Daniel Cameron. Drum roll, please. Daniel Cameron, Attorney General of Kentucky, black man, is married to Mitch McConnell, Republican Senate leader's granddaughter. Yes, I said it right. You heard it here on the Perfect Timing Podcast. I said Daniel Cameron, the person who said the shooting death of Breonna Taylor was justified, the person who said he will not prosecute the police officers who shot and killed Breonna Taylor, is a black man, the first black Attorney General of Kentucky, and he's the first Republican Attorney General of Kentucky since 1944. He's also married to a white woman named, I forget her name, but she is the granddaughter of Mitch McConnell, Senate Republican leader. Bam! Boom, explosion, overpowering, over the top of Mount Osiris, record stop. When I drop them lyrics that'll make you call the cops, don't you dare. I think I just mixed together 2 LL Cool J songs. Explosion, overpowering. Man, come on now. Perfect Timing Podcast. Who else bringing you this information, man? So if you want to know why Breonna Taylor case was not went to court, there was a grand jury. In that grand jury, there was an FBI investigation. The FBI investigation said that the officers returned fire because they were fired upon, so their fire was justified. But that was not the only charges that could have been filed against these officers. No. Like, this officer has been charged for wanton endangerment. The other officers should have been charged for wanton endangerment. Read my description for further details. None of the officers were charged. In that grand jury, one of the jurors gave an interview to Gayle King and said that Daniel Cameron, Attorney General, did not present all of the charges that were possible for the other officers. He only presented charges for Brett. This was a route from the beginning. So now we just heard from the defense some convoluted 9/11. He defended no-knock warrants. He did not speak to Brett at all. He did not defend Brett in that closing Who thought that that was a good closing argument? Somebody put in the chat, was that a good closing argument? Mrs. Perfect Time is in the building. Mrs. Perfect Time said, I'm here in the back tab working. Can't hear, but I'm watching. Thank you, baby. Salute to Mrs. Perfect Time, and I want you to have a beautiful day. I pray a covering over you. I love you. You are so beautiful and a blessing unto my life and to everybody that ever gets the chance to meet you. I thank God that I have met you and have you in my life. I want you to have a beautiful, glorious day. And it's too bad you can't hear your husband say how much he cares about you. And but you know, I pray for your blessing and for your success all day, every day. I love you. But let's get back into it. We're gonna scoot, scat, scat, scat. Instantly, I'm out. Shout out to Hit a Slim. Make sure y'all download that. Skirt, skirt, skirt. Instantly, I'm leaving. So check this out. That was the defense for Brett, right? Breonna Taylor and the people who shot Breonna Taylor are not on trial right now. Cosgrove, who's in my thumbnail, is the person who killed Breonna Taylor. He's not on trial right now. We saw his testimony on day one. The person on trial is Brett for shooting into a drywall, right? So now let's go to the prosecution. Now remember, the state is prosecuting the police officer, right? So let's go to the prosecution's closing argument, and then I got to get up out of here because I got to get a haircut. I got to jump in the shower and I got to get a haircut. So let's go to the closing arguments for the prosecution. Skirt, skirt, skirt. Instantly, I'm leaving. Skirt, skirt, skirt. Instantly, I'm out. Dumping on my people. Skirt, skirt, skirt. Skirt, skirt, skirt. Shout out to everybody in the building, man. Ooh, look at that background. I need some more shit. Look at that background. That background looking good, man. Man, I love my new studio, man. Look at all my pops, man. I got the up there. That's my 10-inch pops up there. Up there, that's the 10-inch. I got a thing up there. I got where Thanos. You see Thanos up there with surrounded in chains. You see Thanos up there surrounded in chains. Oh, that's my Snoop Dogg bump box up there. I had the TV up there. My wife said take the TV down so people could see the Snoop Dogg. She bought me that for my birthday. That's my Snoop Dogg bump box. I got hella Bob Marley. You can't really see. I'm sitting right in front of Bob. There go Bob. There go Bob. What's up, Bob? So there go Bob. And then I got all my pops. We're gonna do a short on the pop. So down here I got Big E. I got the World WWE Triple Tag Team Champions. They all black down here. I forget their name on the bottom, and then I think that's Muhammad Ali. And the kids keep coming in. They used to be in boxes and everything. The kid, my son, oh, that's why Thanos ain't in the box no more. And then the Mandalorian is up there, but you can't see the Mandalorian box is ripped. That was a Target exclusive. So that's Boba Fett from the Mandalorian. That series just ended. What did y'all think of the Boba Fett series that just ended, man? So that's the Mandalorian up there. That's Thing. That's Rick and Morty right there in the car. I still never got my Ice Cube. Ice Cube is back. Binky, if you want to give me Ice Cube. Ice Cube in the 6'4". We've been trying to get Ice Cube in the 6'4" for a minute. So Ice Cube is back if you want to get Ice Cube. Skirt, skirt, skirt. Instantly I'm leaving. Jumping on my people. Skirt, skirt, skirt. Instantly I'm out. Breonna Taylor case, the prosecution closing arguments. This is the state. You just heard from the defense, some convoluted, I don't know what that was from the defense. But now we're hearing from the state, closing arguments. Let's go, let's go, let's go. We're going to get to see video with these closing arguments. This case has really been illuminating. Let's get into it, everybody. Share the video. Perfect Time to Podcast.
Anything to report from the break, ladies and gentlemen? All right. At this time, we will hear from the Commonwealth and Ms. Whaley.
Members of the jury, thank you for serving on this jury. Thank you for being willing to sit here for all these days. Thank you for the attention you've given to this evidence. I say thank you, but I also say that being a juror in this country is a privilege. It's a privilege. Not very many people ever get to enjoy that privilege. We have the greatest system of justice in the world. And being a part of it in any form is indeed a privilege. And now is the most important part of your work as a juror, and that is to render a verdict, to deliberate, to decide, to make a verdict, to apply the law that the judge read to you and that you have now, to apply that law, the law of the Commonwealth, to this evidence that you've heard over these days. The law enacted by the legislature decades ago, the law that you all agreed to follow when we questioned you back at the beginning. And I specifically asked if anyone would have a problem following specifically the law of wanton endangerment. And everyone agreed. I also told you when you came back in to be questioned as a group, the Commonwealth has the burden of proof in a criminal case. The burden of proof beyond to prove the defendant is guilty beyond a reasonable doubt, not beyond the shadow of a doubt. And you all agreed that you understood that burden of proof. And we, the Commonwealth, gladly accept that burden. That's as it should be. This is not a case to decide who is at fault for the tragic death of Breonna Taylor. This is not a case about civil rights violations under federal law or the United States Constitution. Whether this defendant or other officers involved violated Breonna Taylor's rights under the United States Constitution in some way, in some obtaining the way the search warrant was obtained, the way it was served, and the fact that she was tragically killed. Should officers go to prison for violating the federal civil rights laws is not your decision. You heard the FBI was given all the evidence in this case from Detective Hall, including the gun you saw that was used by the defendant that night, that was brought in here in an evidence box so the firearms examiners could show you that gun, and then was taken back. And this is not a case about Kenneth Walker. Whether what he did that night was right or wrong. This is not your decision. Under the law of the Commonwealth, you have seen and have in evidence the search warrant signed by a judge in Jefferson County, a valid search warrant, a legal search warrant signed by a judge. This is not about how the case was investigated before that search warrant was obtained. That is not your decision. Because there's one thing that is a fact. There was no search warrant for Cody and Chelsea's apartment. And that's what this case is about. This case is about the actions of Brett Hankison when he shot into the side of that building in the opposite direction from those who were in the line of fire coming out of the apartment. The evidence that you've seen from the Commonwealth and the defendant's testimony is that he is guilty under this law of wanton endangerment of Cody, Chelsea, and 5-year-old Zayden, whose head was on the pillow right in the corner of that bedroom, closest to where the bullets were flying through. He is who this case is about. Five-year-old child. You didn't hear from him. But that's who this case is about. He's one of the 3 victims who had no idea when he went to bed that night on March 12th what was going to happen in the middle of the night. And it's about Cody, also fast asleep that night, thinking it was an ordinary night, sleeping. And then, boom, awakened out of a sound sleep. And then fast walking to his door to see what is going on, but couldn't even make it to the door because of the debris flying through the wall. Couldn't even make it to the door. And it's about Chelsea. Now she told you she's a heavy sleeper. But even she woke up, was pulled awake out of that sound sleep by the noise, the boom. And was so terrified when she reached for her phone to call her grandma. Her first instinct, call grandma. And what did she tell you? Her grandma couldn't even understand what she was saying on the phone. That's the kind of trauma she was in. Couldn't even understand what she was saying. And just said, call 911. Call 911. And she did. And you heard not one, but 2 911 calls that Chelsea made. Those calls, and you can ask to hear any of this evidence again. Witness testimony, including the 911 calls, videos, you can ask to see any of that. Those calls were so chilling. The voice and the 911 operator, which of course, as they're trained to do, so matter of fact. What is your location? So matter of fact. No kind of comfort. Not the operator's fault, of course, but you can hear the fear in Chelsea's voice. The FBI analyst, Mike Van Arsdale, showed you what you need to know about these bullets that he shot. In the graphic that he constructed from being there at the scene in June of 2020, when the FBI went in and pulled 4 bullets, pulled bullets out of the walls, which hadn't previously been retrieved. When PIU was there that night, they collected everything that was laying there, all the casings, all the bullets in the apartment that had been shot from the door. A few of the bullets that had been shot by the defendant in the opposite direction from those who were in the line of fire. And this graphic reconstruction tells you everything you need to know about where he shot compared to those who were in danger, compared to those who were in the line of fire in the doorway. When the one bullet was shot out the doorway that was found in the breezeway, one bullet, not an AR, one casing from that 9mm found in the hallway, one bullet found in the breezeway, one 9mm found under the bed. You heard from Mike Nobles, the detective who had the ram. Walking up as they were entering, he couldn't see in those sliding doors. There's vertical blinds and there's curtains, drapes, full length. And you'll see in the photos, you saw already in the photos. He couldn't see into those. Nobles is the one who had the ram. Nobles told you he was distracted as he was standing there in the doorway as they were knocking, distracted by Hankison arguing with Mr. Sarpe upstairs. I think all the detectives who you heard talked about this distraction caused by the defendant arguing with Mr. Sarpe. Detective Nobles testified he never saw Hankison in the doorway. He said Hankison was by the steps. That's where he was, at the end of the steps. That's why he could see Sarpe up there, Mr. Sarpe, and was continuing to be confrontational with Sarpe. Detective Nobles told you Miles Cosgrove was the one standing over John Mattingly, returning fire after Mattingly was shot. Tony James told you as he was approaching down the sidewalk, he couldn't see through those sliding glass doors. He was the one with the ballistic shield. He took a position over by the wall right next to the door that says number 3 on it. There is no way any one of those officers who walked up to that breezeway could have failed to see 4 doors in that breezeway where you all went. 1, 2, 3, and 4. Or could have failed to see upstairs. Mr. Sarpe walked out of apartment 8 a door right next to 8, 7, a door right next to 7, 6, a door over to the left, 5, in the same configuration as the first floor. Now, I'll talk a little bit more about that in a few minutes. Tony James told you he also heard the defendant engaging with Mr. Sarpe. And Tony James testified they were very loud about this argument going on. And Tony James told you he did not shoot. Now, unlike Detective Nobles, who had the ram and didn't have his gun at the ready, Tony James did. But when the shooting began, he was engaged in getting out of the line of fire and getting out of there, seeing what could be done to help Mattingly. He did not shoot. He did the right thing. You didn't hear anything about Mike Campbell shooting either. Mike Campbell was at the rear, at the back corner to the left as you're facing the breezeway. Mike Campbell testified that he saw Sergeant Mattingly return fire after the shot came out of the apartment, after the door was breached. He saw Mattingly return fire. Now, Mike Campbell had a good perspective back there, and he could see. He testified he saw Sergeant Mattingly return fire, and he saw Detective Cosgrove return fire through the doorway. He testified he did not see where Hankison was, and he had no idea what he was doing. Mike Campbell also testified Mike, did not shoot. Obviously, Mike Campbell and Tony James were in emotional reaction, trauma, when they realized there was a shot that fired out that door and hit Mattingly. They didn't wantonly just start shooting in revenge. They didn't start shooting in revenge. Well, our fellow officer was shot, so we need to shoot back. No. Mike Campbell got out of there and started doing what he could to help Mattingly. He did not shoot. Miles Cosgrove, who you heard from his deposition, also said Hankison was arguing with Mr. Sarpe, and he used the words yelling. Hankison was yelling at him. Miles Cosgrove realized no one was behind Nobles, who had the ram to cover Nobles, because Nobles didn't have a gun. He had the ram, or he didn't have his gun drawn. So Cosgrove moved up. Once the ram starts the first hit, Cosgrove moves up to cover Nobles. That's why he was in the threshold, in the line of fire. After Nobles breaches, Nobles spins out of the way to the right. You saw the ram laying on the ground there to the right of the door. So that's where Cosgrove is when the door is open. He was in the threshold after Nobles spun around. Cosgrove said he saw the figure in front of him and he saw the gunshot fired at him and he fired back. You know from the round counts that were done at Public Integrity Unit where all of the officers guns were taken down there and unloaded with the magazines unloaded. That's called the round count, how many rounds were missing. So it could be determined how many shots were fired by each one of the three who shot. Mattingly fired 6 shots. There were 6 rounds unaccounted for in his round count. Cosgrove fired 16 shots in the doorway. Mattingly, 16 shots from the doorway. Lieutenant Lacefield, the firearms instructor commander, told you, when asked, how long does it take with this Glock 40 caliber Model 22, the service weapon, the one you saw, how long does it take to shoot all of the 16 rounds in that gun, which it can hold if it's fully loaded with one in the chamber? And he said 4 to 5 seconds. 4 to 5 seconds. Cosgrove said he did not realize he had shot 16, but all of his shots are here in the doorway after the shot came out and hit Mattingly. He was in the line of fire. Hankison's round count, 10 rounds missing. And all his casings are accounted for. All his casings are accounted for out here in the parking lot, 10 of them. All these casings that you'll see in the photo in the breezeway were identified by the Kentucky State Police firearms examiner Stephen Hughes as having been fired from Cosgrove and Mattingly's guns, because that's where they were, in the doorway, responding to incoming shot from the hallway. One shot, one bullet, which went through Mattingly's leg and was found over by apartment 1 door. I know you all have heard the old saying, a picture is worth 1,000 words. So nothing can take us there to actually witness what happened. But I want to go back over some of these photos to refresh your memory of some of the testimony. This is the overhead of the complex that you saw. Now, I want you to pay attention to when the defendant was on the witness stand. I asked him with this photo to show how he drove in that night and where he parked. And the main road out here, I guess St. Andrew's Church Road or St. Anthony Church Road, out here, and then you come up this way and turn to the left and come down, because you can't get in this way, or couldn't on March 12th because of the gate here. So you come up this way, turn in to the left to this road and drive through here and around. And this is the dumpster. And that is where, in this area, is where Hankerson said he parked. Some of the other vehicles were parked in this area as well, except the white van, of course, the van that the Sequoia that Mr. Sarpe was driving was here, parked perpendicular to those. And then I believe the white SUV that Mattingly was driving, you heard, was right behind the Sequoia. But here's the important thing. When you drive in this way, it is obvious that this is a complex of apartment buildings. You drive through here and you are seeing the patio and the balcony of this 2-story building. The 2 patios, this is only an 8-plex right here. These other 3, and this one also, are 16-plex buildings. So that you have, in this one, you have 4 apartments on the first floor, 2 at the front and 2 at the front and 2 at the back. And then on the second floor, you have 4 more, 2 at the back and 2 at the front. So that you have 2 patios and 2 balconies. And then in the front, the same thing, 2 patios and 2 balconies. But in the 16-plex buildings, you have 2 on this side of the building, 2 patios, 2 balconies. And on this side, 2 patios, 2 balconies. Patios downstairs, balconies upstairs. And the same at the front. So that it's obvious as you are driving around these buildings that you see, oh, here's 2 balconies and 2 patios on this side. And over in the front, the same thing, 2 patios and 2 balconies. So, same thing with the 16-plex, which this is the building, 3003. And here's number 4 right here. Before you can even get to 4, as you're walking down the sidewalk or the parking lot, you have to pass this set, which is identical to these across the street that you have already passed as you're driving through and seen, oh, there's balconies and patios in back of these buildings. Oh, here's the front. There are patios and balconies in front. So if you're a trained observer, say, for instance, a police officer, a 20-year veteran police officer trained to observe your surroundings for 20 years, you're going to take note of the surroundings as you drive in and approach the target destination, which is apartment 4. These buildings are identical. So this is the back of 3003. And right here is Cody and Chelsea's patio and railing there, just like the one in the front. No, you can't see it from the front, but you can see the doors. You can see apartment 3 door with a big 3 on it within 3 feet. You all were there. Within 3 feet of apartment 4 is the door right there with a big 3 on it. But you've already seen these buildings driving in. Oh, there's patios at the back, identical to these. Next photo. And here we have the breezeway. And actually, even in this photo, it looks larger than it is. In reality, it's just makes it look larger than it is. But you see how close these two doors, this is apartment 2, and then directly across, this is apartment 4, of course. Directly across here was the door to apartment 1. There is no way that he didn't know. There's another apartment right here. Next photo. Another photo of the breezeway, and now we can see apartment 1 door, 2, 3, and here's 4. And this was taken, and you heard Lieutenant Vance testify about the Sergeant Vance. Markers. These all represent casings collected. All the .40 caliber casings from the guns of Mattingly and Cosgrove, because that's where they were when they shot from the line of fire. And here, marker 37 is the bullet that was collected, that was identified by the FBI firearms examiner, Bryce Ziegler, this bullet here, as having been fired from the 9mm found under the bed in the south bedroom of apartment 4. The bullet that went through Mattingly's leg and ended up right here. The rest of these markers are all casings that were ejected by the guns of Mattingly and Cosgrove, because they were the ones in the line of fire, not this defendant. He was over here shooting wildly through sliding glass doors covered with vertical blinds and drapes. Now, in the daylight the next day, when that picture counsel showed you of the bedroom window with the black drape, that was taken the next day in the daylight. And he wanted you to see or believe that you could see through it, because, oh, by now it has bullet holes in it. And it's daylight. So yes, you can see daylight through the bullet holes the next day, but not that night. Next photo.
Oh, she's whooping him. She's whooping him. Oh, she's whooping him. What did the defense do? I don't understand what the defense did. Applause again. Another great prosecution from the state. She is whooping him. What did the defense do? What is his real defense? If you listen to the defense's closing arguments, they have no real defense. Now she's really just obliterating their whole case. You should have defended why he shot and what he shot at. What she has established is everyone should not have shot the gun. What she just established is everyone should not have been shooting. It was 7 police officers. The only 2 officers who returned fire and should have been returning fire were the officers who were fired upon. All of the other officers took cover and went to protect the other officer. The only other officer who shot was this clown who got into an argument and almost got everybody killed and almost blew up the whole thing. He's arguing with a neighbor. The sergeant couldn't even testify as to what happened at the door because the sergeant had to address Hankerson and tell Hankerson to STFU. Hankerson, she just showed was the kill zone. 4 doorways. Plus, she established that when he drove up, he had served a search warrant there before. And there was no way after 20 years of being a police officer, you did not know that there was an adjacent apartment. This case is not about the no-knock warrant. This case is not about the gunshots being fired at Cosgrove. This case is about you shooting wildly when you had no reason to shoot. Same thing with Kim Potter. Kim Potter should not have never even pulled her taser. That's why Kim Potter should be in jail for 20 years, because the expert testified that that she never should have pulled her taser. There was no justification for you to shoot, Hankerson. You were at the back of the pack. You were not in danger. No one was shooting at you. You were not in the line of fire. You do not get to shoot back simply because a police officer was shot at. You are not in the game. If you see how she established that, you do not get to shoot back in revenge as a police officer. It is not an excuse for you to shoot back simply because you were shot at. That is what she just established. Great job. Great job. What did the defense establish? You got to remember, as a juror, what will be your defense? The defense only established that he had a right to shoot because 2 officers were fired upon. Now, what she is doing is telling the defense the law. Police cannot just shoot. Thank you. Thank you. Police cannot just shoot. Police cannot just shoot whenever they want to and do whatever they want to do. She just established police cannot just shoot. You have to have causation for you to shoot your gun. And then when you shoot, you are a 20-year professional. You have to be shooting at something. You cannot just shoot willy-nilly and then come to court and say, I didn't know there was an apartment there. How do you not know there was an apartment there? That's why she's showing the picture. 4 doors. You're standing here. How could you not know there's an apartment there? You should have known. Now the city is liable for $36 million. $36 million because your stupid ass shot into an apartment. Scared. He was scared. That's why he was arguing. If you ever been on the run before, it's always somebody, this motherfucker scared. Why are you worried about this shit over here? We got business to take care of. You know why he was talking to the goddamn neighbor? Because he was scared. He was scared to go in the door. He was scared to do the hit. That's a fact.
These markers are the defendant's casings. Every one of these, 5, 6, 7, 8, 9 is under the tire, 10. Here is the sliding door with the bullet holes in it, and the window with 5 bullet holes. 5 bullet holes in the sliding door and 5 bullet holes in the window. And here's the casings. These up here in the gravel were testified about by Sergeant Vance that were weathered casings. And you may have noticed some when you were out there that were laying and had been there a while. So these up here in the gravel were not relevant. These all in the parking lot were identified by Kentucky State Police Examiner Stephen Hughes as having been fired from the defendant's service weapon. Every one of these casings was a positive identification by Stephen Hughes with Hankison's .40 caliber Glock. Next slide. And here's 2 more. This is not a casing. This was a magazine that was dropped. 1 and 3, marker 1 and 3 are 2 more of Hankison's casings, both identified as positively having been fired from his service weapon. Next slide. Again, 1, 3, and now you can see marker 4 between the 2 vehicles in the parking lot, another casing that was positively identified as having been fired from Hankison's gun. Next slide. Close up of the sliding doors. Now, obviously, we can see through them now because the curtains are pulled back, the blinds have been pulled back so that they can see the bullet hole, the bullet defect. 1, 2, 3, 4, 5. Shattered glass. Next. Now this we're going to follow the pattern of those 5 bullet holes we just saw. So this is taken from the inside, of course, and they have pulled the curtains back, and you can see the bullet defects in those. Here you can see some of the blinds that had been broken down during the shooting. And you can see shattered glass here, but some of the vertical blinds that are now laying on the floor. Next. Now, the bullets have been shot through the sliding glass doors, and here is where they went through the wall that's straight ahead, looking through the sliding doors. This wall is straight ahead. So this is the common wall with apartment 3. And we have one defect here, which this bullet is the one that ended up falling down and was laying on the carpet. So that's that one there that was collected. And later identified by FBI examiner Ziegler, and he described it as a bullet jacket that was found here. It didn't make it through, and he identified it positively as having been fired from Hankison's gun. So that's one. And then we have 2, 3, 4 bullet holes here. Next slide. And now we can see the 5th one. First one was the chair. Now we can see 2, 3, 4, 5 holes going into the wall. And next. And now we can see the trajectory rods that examiner Van Arsdale, who created the graphic, during his work, he was measuring from the entry hole into this wall through to the drywall of apartment 3, where he could still see, even though the drywall had been repaired in apartment 3, he could still see where the hole had been in order to make this trajectory. These are the 2 clock defects right here, which you'll see on the other side. And then you'll see this one. This hole here is one that the bullet ended up in the stud. So this is the stud, and the bullet was pulled out of the stud by the FBI, and it was identified by firearms examiner Ziegler as having been positively fired from the defendant Hankison's gun. This one. These 3, this one, these are the 2 clock ones you'll see. And then this is the one that went straight through to the chair rail or bumper on the other side of the wall. Next. So now this is apartment 3, where they have come through the bullets. It's a mirror image of the other wall. So here's the clock, defect here, or bullet coming through here, bullet coming through here. And then the third one be the next slide. Third. So there's the chair rail in apartment 3 that mirrors the entry hole on apartment 4, and here's the exit on apartment 3. Now we'll see where this bullet, and there's this bullet, ends up on the dining room table of apartment 3 that came through over the chair rail. Next slide. Now the second bullet that was found that came through one of the bullets came through the clock. We'll see in the next photo, hit up here and then drop down on this carpet. Next slide. So here is the bullet. One of the bullets that came through the clock and then hit up above the sliding doors and then drop down on the carpet. That's the second bullet they retrieved from apartment 3. Next slide. And here is the hole in the vertical blind where one of the bullets that went through the clock kept on going, and that's where the one that probably almost hit Cody as he was walking through, and went all the way through the blind and shattered the sliding glass door. This other bullet from the clock ends up here, doesn't make it through, and falls back down on the carpet. Well, this is the one that shattered that door and left then it wide open with shattered glass everywhere. Next slide. The window bullets. This is the 5 window bullets. 1, 2, 3, 4. 1, 2, 3, 4, 5. You can see here, this of course taken in daylight the next day. You see these are the horizontal blinds. Now you see how close those blinds are together? Well, those were down. There's defects in them now. And covered by the black curtain on the other side. Next photo. And here's the other side where those bullets came through. Fired from here on the graphic. So 5 bullets were fired at that window. One of them you heard about was found, it came through and hit this dresser drawer and then ended up inside the dresser drawer. That's one. And the next. 2 more hit this wall as you're facing the window. It'd be the wall to the right. And there's the defects. And those 2 were later found in the wall by the FBI in the search in June. Those 2 were pulled out and they were tested by Bryce Ziegler and found to be a positive identification to Hankison's gun. These 2 bullets here pulled out of the wall. So that's 3 bullets so far from the window that were retrieved. Next slide. So here's the 4th one. This went into the utility closet in the hallway here. And there it is, the bullet right there. That was retrieved, and that was positively identified as having been fired from Hankison's gun. That one was retrieved during the crime scene unit search, and that one was identified by the state police as having been fired from the gun of Hankison. Next slide. And this is the 5th bullet through the window that was found in the soap dish. That obviously you don't see any defect behind it, but must have ricocheted from somewhere in here. And here it is, right there. The 5th bullet through the window. So we accounted for all 5 in the sliding door because we had the one that hit the chair and fell on the floor. That's 1. One that got stuck in the stud that was pulled out later. That's 2. And then 3 of the ones fired through the sliding door that went all the way into apartment 3. Those are the 3 important ones. Because any one of those 3, 2 that went through the clock, especially those 2 that went through the clock and then through the clock in apartment 3, and 1 all the way out the sliding door, could have any one of those. In fact, any one of the 3, even the one that went through the chair rail and ended up on the dining room table in apartment 3, could have taken another deflection. You know, who knows where it could have deflected out of that clock. Instead of going through the sliding door in there, could have gone into that bedroom where little Zayden had his head on the pillow. Next. And here is the 9mm that was found under the bed in apartment 4. Right here is the south bedroom, found under the bed. That was collected, tested by both the Kentucky State Police, the Kentucky State Police examiner, Mr. Hughes, made a positive identification of the casing found in the hallway. The casing found in the hallway was fired from this 9mm. One casing. One bullet was found in the breezeway, marker 37, that the FBI examiner, Mr. Ziegler, positively identified as having been fired from this 9mm. Next. Now we're back out to the front. And we see, again, the defects, the shattered glass, the railing up, or the balcony up here. Apartment 876. There's the Christmas tree that Cody Etherton told you they had set out in this bin, and that's where it ended up. Another view of you can see the relationship between the sliding door and the window. You definitely have to change position to start shooting, stop shooting from this sliding door and start shooting through the window. It wasn't all just one action. There had to be a position change, continuing shooting blindly into the side of this building. There were no AR bullets found anywhere. Anywhere. There were no bullet defects in apartment 4. If this person was standing here with an AR shooting out, where are these defects? Who got shot with an AR? You didn't hear any testimony that any of these officers, including Mattingly, who did get shot, but who got shot with a 9mm, one bullet. Who came in and said they were shot with an AR? There was, Cosgrove was right there. Where's the bullet defects of all this AR shooting going on? And there was no bullet defects in these walls. There were no bullet defects bullet defects of exiting anywhere of an AR. There were bullet defects coming in from Mattingly and Cosgrove that went in to these walls that were fired from out here. The reason there were no AR bullets, no AR bullet holes, and nobody that got shot with an AR is because there was never one. When Lieutenant Vance interviewed the defendant, he couldn't remember which way the door opened. When Lieutenant Vance asked him in that interview, which way did that door open? He couldn't remember. It's in his statement. which way the door open, and he responded, I can't remember. That's because he was never in the doorway. The only ones who had ARs or long rifles in that night, the only ones were the patrol officers that he called out and told, we need long rifles. We need long rifles. So you know what that did? You know what that did when they all showed up with long rifles, the patrol, all out behind that first slide that shows the overhead of the complex. And you saw on the body camera of one of the patrol officers with the long rifle pointed at Cody, and he testified he was standing there with his hands out the window of what used to be the sliding door, and they were pointing rifles at him, and there was a dog back there barking. He was afraid it was going to lunge at him. That put him at even more risk of serious physical injury or death caused by this defendant telling them to come out with long rifles. Now, I want to look at the instructions. There they were. Back here with the long rifles pointed at Cody. Instruction number 4, all the wanton endangerment ones are the same. That in this county on or about March 13th, for the finding of the indictment, he discharged bullets from a handgun into apartment 4 that entered apartment 3, which was occupied by Cody Etherton. Now, this doesn't require, nowhere in this instruction are you going to find anything that says, that asks you to find that he knew that Cody Etherton, per se, was in that apartment, obviously. You are not required to find that he knew there was a man named Cody Etherton in that apartment. If that was the case, this would be an intentional crime, not a wanton endangerment. It would be some sort of intentional. B, that he thereby wantonly created a substantial danger of death or serious physical injury to Cody Etherton. That under the circumstances, such conduct manifested extreme indifference to the value of human life. Now, and you have a definition of wantonly. But I want to look at let's look at how the evidence has proven this. First, the instruction says he wantonly created a substantial danger of death or serious physical injury and this would be to Cody, to Chelsea, and to Zayden for each count. And that under such circumstances, such conduct manifested extreme indifference to the value of human life. So how has the evidence established this? Go on to the next. So wantonly. The definition of wantonly states a person acts wantonly with respect to a result or circumstances when he is aware of and consciously disregards a substantial and unjustifiable risk that the result will occur or that the circumstances exist. And this risk must be of such nature and degree that disregard thereof constitutes a gross deviation from the standard of conduct that a reasonable person would observe. So you have to find that he was aware of the risk of shooting blindly into this building. There's the building. Well, there's where the bullets went through, but the building, the side of the building, the front of the building, where there was no view, through the sliding glass doors and the window. That wantonly, he has to be aware of the risk. And how do we know he's aware of the risk of shooting blindly? Well, because he has 20 years of training as a police officer. He has 20 years of twice a year having to go to the range and sit through not only classroom instruction and simulators, but actual firing at the range, shooting at a silhouette target. Because that's where you're going to be using defensive force, deadly defensive force, is against a person who's a threat. So that's why they have silhouettes shaped like a human body. And he couldn't even tell you that after Officer Gelhausen explained, yes, we use the silhouette as the target in these exercises out on the range. And we call it LMPD blue because it's a blue color. So 20 years of training, he's aware of the risk of shooting when you don't have a target. And he consciously disregarded. He ignored that risk. He consciously disregarded it. And he shot wildly in the wrong direction. And a threat can be a muzzle flash. What did Officer Gelhausen tell you about that? Seeing a muzzle flash. It can be a threat, but it has to rise to the level of an active threat. It can't just be a threat. A threat is not something that requires that you shoot at it. It has to become an active threat. There has to be a person at the end with a gun that caused that muzzle flash. It has to be an active threat. Officer Gelhausen said, if a person is standing there with it, and you can see they've got a gun even down to their side, that's a threat, but it's not an active threat. You don't have a right to shoot somebody who's just standing there with a gun down to their side. And he told you. Now, if they raise it and point it at you, then you do have a right. That's an active threat. So he was aware of the risk of shooting blindly, and he disregarded that risk and shot wildly in the wrong direction. Next. He created a substantial danger of death or serious physical injury. Cody Etherton was at absolute risk of substantial danger of death or serious physical injury. And serious physical injury is defined for you. It's very straightforward. Chelsea was in substantial danger when those bullets came through. They could have deflected instead of hitting that clock and going straight through to the sliding door. Any one of those three bullets could have deflected off that clock and gone to Chelsea's bed. Or even as she stood up. Any one of those three bullets could have hit little Zayden in that bed closest to the line of fire where they did come through and go out the sliding deck. A little deviation in degree and angle of those bullets as they came through this wall and through that clock and any deviation in the angle as they deflected could have hit. Three bullets came through. Any one of those three could have hit Cody, Chelsea, or little Zayden. Next slide. Circumstances. So the instructions states that that he wantonly created substantial danger of death or serious physical injury, that under the circumstances, such conduct manifested extreme indifference to the value of human life. So what are the circumstances? Okay, the circumstances under which he fired wantonly. Well, you have a 16-plex building, as I went through with that overhead, and you're driving through there, you can obviously see all these apartment buildings, and you drive right past two of them. You drive right past the ones that you're at the back, and you see, oh, 1, 2, 3, 4, 5, 6. And then you drive around and you see, oh, here's the front. And 8 more in the front, 8 in the back, 8 in the front. More circumstances. Testimony from the defendant himself. I told him, this is him telling Mr. Sarpy, I told him to go back in numerous times. His focus, when everybody else was focused on that door, on the knocking, on trying to get a response so they could peacefully serve the search warrant. When everybody else is focused on the job at hand, he is talking and arguing with Mr. Sarpy upstairs, taking the focus off. Mike Nobles, the one with the ram who's got the most important job at that time. Mike Nobles, the most important job. He's the one with the ram. And then they said, go ahead. He didn't want to have to use that ram. Mike Nobles, this distracted us. The argument with Sarpy took our focus off the door. More circumstances. Next slide. He's the one that directed the patrol to bring long rifles. Cody was in more danger with rifles in the back. More circumstances. His wild shooting with no target, with no reason, put fellow officers in jeopardy. His shooting from this sliding door, while they're still here in the fatal funnel, he was never in the fatal funnel, ladies and gentlemen. He was out here. His shooting wildly through this sliding door put his own fellow officers at risk. Look at this angle. They're still in the fatal funnel. Circumstances, the doors in the breezeway are clearly visible. A trained officer, trained 20 years to observe his surroundings, especially in a situation like this. What you won't find in the instructions is anything that requires you to find a motive. You're not required to find or know why he did this. We'll find that in there. You won't find anything in the instructions requiring you to find or consider whether he acted in self-defense or whether he acted in defense of another. You won't find that in the instructions because that, once again, would have required an intentional shooting. That may be something that would have been applicable to those that were in the fatal funnel who did shoot back intentionally. You won't find in these instructions anything that requires you to decide why he did this. And the facts are, he actually came in here and told you that he was standing on the doormat and saw the flash straight ahead in the hallway. And then when the hallway lit up, he saw a figure in a tactical stance with a long rifle. He actually came in here and told you that he was the one standing in the doorway and saw the shooter. Okay, well, the fact is that didn't happen. Because if he had been there, he would have shot then with a real active threat in front of him. Like you heard Mattingly and Cosgrove, who were the ones there, who were in the fatal funnel, who did take fire, who did take a bullet and fired back. If he had been the one standing there instead of Mattingly and Cosgrove, yeah, we wouldn't be here. It may be in another situation, but it wouldn't be. He may be in another situation, but we wouldn't be here. He was never in the line of fire. You do not have to find why he did this. Next slide. His wanton conduct could have multiplied one tragic death, Breonna Taylor. His wanton conduct could have multiplied her death by 3. Easily. This is what this case is about. This is who it's about. By grace, they're still alive. I ask that you find, based on this evidence, that this defendant is guilty of wanton endangerment under the law of Kentucky for his conduct that night. Wanton endangerment of Cody, of Chelsea, and Zayden. Thank you.
All right, ladies and gentlemen, we are very glad to still have all 15 of you with us, but only 12 by law are able to deliberate this case. So we'll randomly draw out 3 of your number, and I will call those out. When you hear your number called, just please remain seated. Juror 289-5941, Juror 289-6551, Juror 289-5881. Do you solemnly swear to keep the jury together, to allow no one to discuss the case with them, and to not do so yourself?
I will.
All right, thank you. All right, for the 3 of you whose number I called, could you just raise your hands, the 3 that I called your number? All right, if the 3 of you will just remain seated, and then we'll let the other 12 of you go back to the jury room to begin your deliberations. You are released from the admonition that you're not to discuss the case with each other. Please discuss the case with each other fully. As I said, we'll send the exhibits and the original of the instructions back to you in just a few minutes. I believe your lunch is either here or on its way.
Is here. If you want to have your lunch, the three that remains here, just wait and I'll bring them to you. All rise for reporting the morning.